Any mention?
Yes.
My lord, in respect of item number 5, my lord,
Yes.
I am appearing petitioner and respondent, they were supposed to file affidavit. But my lord, respondent counsel Mr. Chetia informed me he is suffering from my lord illness, your lordship. So he told me that
Number 5 in orders. Let it be called out, Mr. Goel.
my
Item number 1.
Hello, sir. I need some accommodation for today.
What accommodation?
Sir, I am not feeling well. Today I am not feeling well.
You're looking perfectly healthy.
I feel okay, but I am not feeling well. That's why.
Yes. When you want in?
After a week,
as the third counsel for the on the pre-order counsel of appellant, the personal difficulty. Just after?
After a week.
After 1 week. Yes.
Item number 2.
He's not? They sit together. Now together has come with this last order was this is this, sir. Now this matter is listed together with Case 91, which is listed together with Appeal 93. Where's Mr. Sheikh? What's the stage of this matter?
He spoke to me yesterday. He said they're engaging a senior counsel, so he has some difficulty in doing the matter today. So there's another appeal which has been preferred by one of the contesting parties. That is item number 3. So it is stacked together, my lord.
Who's appearing at number 3?
Item number 3, it shows Mr. Sangriso.
No, the petitioner is Mr. Sangriso, my lord.
Yes. Where's Mr. Sangriso or his juniors? You're there. Very good. Then number 4 is appearing. Number 4, Mr. Chakravarti.
No, it's number 4 is a different matter.
Oh, sorry.
Only 2 and 3.
2 and 3, my lord.
What to do then? Number?
It's even item number 3. I'll be entering appearance for one of the party. I'm just yet to check the cost title, my lord.
Only the Sheikh. You're number 7. And you are number? Item number 3. Take down Mr. Amar Marak has entered appearance today on behalf of the respondent number 7. Mr. Sen?
So it's for... I'm sorry, my lord. This is a different matter. Here I'm not a party. The managing committee has not been arrayed in this case.
Yes, number 7. That means arrest all state respondents.
Lordship.
You are appearing. Yes. That means notice is complete. So and so as such notice complete in the instant appeal. Stop. As stated that Mr. S.A. Sheikh, conducting counsel on behalf of the respondent number 7 in item number 3, and in the other matter, he's what? Number 2, he's whom?
Number 2, respondent number 2.
That's what 8 in WPC in item number 2.
2 will
is tagged together. And this matter up to 1 week.
No, sir. Obliged, my lord.
Obliged, my lord.
Item number 4.
Please, Your Lordship.
Yes.
But there's a application for condonation of delay, and the
Delay has
delay.
been condoned. Oh no. Yes. Where's Mr. Bora? Last time he appeared virtually or he appeared in person?
Mr. Bora, PK Bora?
No. BP Bora.
Oh,
For
from
227.
Guwahati.
What about? Do you have any objection to the condoning of the delay?
No instructions, Your Lordship.
Actually, ma'am, the main interested party is the bank only here. But since in the writ petition, the Union of India was made a party,
Okay.
so we have
Your
made.
Lordship, a week's time may be given, Your Lordship, to see
No,
instructions.
we will. Doesn't matter. If we are not a registered party, then we'll condone. How many days delay is there?
227 days. What's this?
Where's the petition? Where's the Agamis case? This one. Where's the petition? Agamis case petition.
Well, in the last order, it's recorded that Mr.
BP Bora has no objections.
My Lord. But probably no order was passed because I was not there.
Yes.
That was the reason.
That is the reason.
Somebody had appeared on my behalf. That is it.
Yes. Then since we recorded that, then we'll condone the delay.
All right.
How many days? 219 days.
227 days.
That's why? What's the reason for the delay?
Well, basically, it's because of the lawyers.
Which paragraph have you?
My Lord,
You were the counsel only? No.
yes, in the law court, I was the counsel. In para 3, my Lord.
Okay.
But then it is not for a senior advocate to prepare the pleading. It has nothing to do.
Of course, well, some guidance is required.
We've seen that proper guidance for the preparation. Anyway, heard Mr. S. Chakravarti in the Miss case 93-24 on the prayer for condemnation of delay. Let's say counsel has submitted that the delay caused was due to the inability of these handling the matter into unavoidable circumstances. Therefore, prays that as the appellant the delay of 227 days be condoned. It appears on all the sheet that when the matter was taken up last, this court by order date 20/02/2025 had recorded the submissions of Mr. BP Bora, counsel for respondents 2 to 7, were the main contesting respondents. That the said respondents had no objection to the condemnation being allowed. However, Mr. Bora is not present for today. Be that as it may, in view of the submissions made on the last date, the same is duly taken note of, and the delay of 2 to 7 days is accordingly condoned for the reasons stated in the application. Registry to diarize next paragraph and lists the matter for admission. This case stands disposed of. And in the main case, in view of the order passed and so and so, this is a matter for admission on so and so date.
It needs to be registered also.
Yes,
Admission.
Item number 5.
Obligation.
Yes, Mr. Goel.
Very.
In this matter, respondent, my learned friend is there.
My lord, I am seeking 3 weeks further time to file our affidavit. This case.
Why so much time?
My lord, we have already received the instructions, my lord. Only to file it, my lord. My lord, at least 2 weeks, my lord.
Okay, Mr. S.N. Chetia, on behalf of the respondents number, all the respondents,
All respondents.
Lord,
principals not for the 2 weeks time to file affidavit. This is the last one also.
Hearing. Item number 6.
oblige.
Yes. Maybe last time.
I have prepared
Where's
the
the Dr.
proposed
Your
substantial
Lordship,
question
he's
of
stuck in
recast.
traffic, Your Lordship.
He's stuck in traffic.
Yes, Your Lordship. Lordship, therefore I pray, Your Lordship, if this matter may be listed after 1 week, Your Lordship.
I have
You do one thing. Yes, you. You have given her a copy.
yes,
of
I have given a copy.
Yes, a recast of suggested questions of law on behalf of the appellant has been filed by the council today. A copy whereof is made over to the MS Argurum, appearing for the respondent's vice, Dr. Muzika. This is matter after 1 week.
Much
Pending of suggested questions of law by the court. Yes.
Much
Give you suggestions also. Yes.
Much obliged, Lordship. Item number 7.
We'll have to wait for.
Yes, ma'am. In fact, I'm willing to take a statutory appeal. I'm willing to file the statutory appeal. So your lordship may direct the only thing is that the time period spent in the writ petition may be excluded.
Your Lordship, pertaining to that also, Lordship, I need to say instruction, Your Lordship.
Yes.
Pertaining to that also, Lordship, I need
Regarding
to
the condemnation.
No, Your Lordship, not regarding the condemnation, but then he's willing to dispose of the matter with certain statutory.
No, but the appeal, the statutory appeal is my right, and I'm not. I'm willing to go that way. So your lordship may.
You're forfeiting your order obtained from Manipur High Court.
My lord, that order is as things stand now, by virtue of the impugned order in this case, that order has become infructuous. I cannot do anything with that.
That is your
Absolutely.
entirely your discretion.
Absolutely.
Right. Then we'll. Yes.
Lordship, if this matter may be taken up tomorrow, then in that case, Your Lordship, he can
Again,
come through
specific-
VC, Your Lordship.
Then fine, Mr. Musa, you appear virtually in the next date. Let the orders be passed in presence of the DSGI.
Yes, Your
I
Lordship.
shall wait today, my lord. In fact, my flight is only tomorrow. Even in
No,
late.
because the thing is that this bench is breaking now, and my brother has to go and sit with the Chief Justice also. So that, and I'll be taking up single matters, a lot of single matters.
Tomorrow, I'm leave.
Then we'll do one thing. We'll dispose it of. We'll pass
Lordship,
orders.
Yes.
Your Lordship, I'll just need to talk to my senior in that case, Your Lordship.
Well, there is nothing. I'm not pressing anything in the writ petition.
He's not pressing.
I am not pressing anything in the writ
At
petition.
least tomorrow, Lordship, he can come through VC, although he is.
No, I'm trying.
You can do one thing, Mr. Musa. You just withdraw the writ petition with liberty to approach to alternate
No,
remedy.
my lord, what will happen is the statutory adjudicating authority will dismiss my claim saying that it's barred by limitation. Only if this court says that it's excluded under section 14 applies to 128, the appeal under section 128. So that if that is
But that when you file the statutory appeal, you have to put in an application.
yes,
also.
I'll put it in the
appeal considered
application.
favorably. That's all.
Yes, but that may be mentioned. I mean, it's to protect my
Right.
the
Then
client's
we'll
interest.
record it.
Lordship,
Yes.
it's just a matter of a day, Your Lordship. He can come through virtually, Your Lordship, tomorrow, Your Lordship.
Anyway, okay.
My lord, I came specifically for this from all the way from Kerala.
You can enjoy the rest of the day. Yes, the flights in the evening.
I fly out tomorrow, my lord. Even if it is taken up later during the day, I shall appear. Not a problem.
No, once a bench breaks, it can't be. It has to be notified again. You see, and once notified again, the Chief Justice is the master of the roster. He has again, so that we can't take. Is he coming now?
He's on his
Where
way.
he reached?
Polo, Your Lordship.
He reached Polo. Then after 1 week, Mr. Musa, you appear virtually.
the same submissions.
Same.
Shall I submit the authorities now for your lordship's
Not
perusal?
necessary.
Not necessary. And might I mean, I'm under the impression that your lordship is not against
Yes.
excluding the time period spent during. Okay.
Yes, I heard Mr. Harris Musa, right?
Harris Musa.
Yes, learned counsel for the petitioner, who submits that the petitioner is willing to pursue the matter by filing a statutory appeal before the custom authorities. Stop. And he also praised that the period spent in pursuing the matter before this court be given consideration,
Be excluded.
be considered for exclusion when the appeal is taken up by the customs. It's the appellate. It's called
Commissioner Appeals, man. Commissioner Appeals under 128.
Next paragraph. MSR Gurung, however, appearing for the respondents, has prayed that the matter be taken up to 1 week due to the absence of the senior counsel in the matter stuff. At least after 1 week. So we recorded your submissions, right? Next after 1 week we'll take it.
Highly obliged, Lordships.
Obliged.
So sorry for that.
Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item 24 and 25, Your Lordship. I have taken the consent from. Your Lordship, a similar prayer for item 18 and 19, Your Lordship, all connected matters. Highly obliged.
2 weeks.
Highly obliged.
At the request of funds.
Your Lordship, I beg to mention item number 20, Your Lordship.
20.
20.
You have an objection?
No, my lord.
2 weeks, Your Lordship.
May I please, Lordship, I beg to mention item number 22, Your Lordship. Due to some personal difficulties, Your Lordship.
22? Who, Mr. Changri is not here today?
No, yes, Your Lordship.
Is out of station.
This is a promotion matter, Your Lordship.
How long? 1 week?
For 2 weeks, Your Lordship.
Yes.
Supplementary list item number 1.
Please, Your Lordship.
Yes.
Your Lordship, the matter is related to promotion to the post of assistant headmaster of the school in a secondary school. I have prayed for, though the petitioner is senior most teacher in the school, Manikan Secretary North Karo Hills, but he is deprived earlier also, but recently also a resolution was taken by the SMC to deprive the petitioner. And they
To promote the petitioner. What happened?
That case of the petitioner not considered, though he is senior most teacher, but only.
What happened? The MC have
SMC taken resolution and submitted before the district office as well.
Submitted.
I have submitted the representation.
Rejected.
Lordship.
Been rejected?
No.
Then?
No, my case is not considered. Though I am the senior most teacher, but my name is not forwarded to Your Lordship by the SMC resolution.
Or not for the SMC?
SMC, they take the decision that I have not considered B.Ed degree possessing. I am not possessing the B.Ed degree, but it is not considered as per law, Your Lordship. It is covered, this case also covered your judgment passed by Your Lordship. Also decided, page 26.
26.
Annexure 5.
This is in this similar case?
Similar case, Your Lordship.
Yeah.
But in case, petitioners, in this case, this judgment, SMC considered, forwarded to director not considered. Then Your Lordship direction that it was considered, director has considered.
And the person was given promotion?
Promoted, Your Lordship. But in instant case, in this case,
the SMC didn't consider.
They did consider. The established.
Lordship will take instructions, Your Lordship. There's a private respondent
no, but the
also
thing is
here.
that then you have to issue notice
To the private respondent.
Management committee first. Yes, sir. Heard Mr. S. Islam, correct?
Lordship.
You can't issue notice. MSD, Yangi, P, AG with source present except those on behalf of the respondents 1, 2, and 3.
1 to 5.
Notice to issue to response 4 and 5.
1 to 3.
Within 2 days by registered AD. This after 2 weeks is for instructions after
5 registered post.
Yes.
Private respondent also there.
Yes, you take step from them.
Until that, post may be vacant, Your Lordship.
Not right now, yes.
Item number 2.
Obliged.
Please, Your Lordship. Your Lordship, this matter pertains to the non-issuance of the NOC, Your Lordship, over landed property situated at Nongra by the respondent Dorbasnong, Your Lordship. Your Lordship, in this matter, due to the non-issuance of the NOC, Your Lordship, I was...
NOC for?
for over landed property, which is required for the purpose of registration in the form of deed of declaration, Your Lordship, because the property was originally belongs to my father, Your
Why
Lordship.
should the Darbar, for deed declaration, why do you need the Darbar?
Your Lordship, as per, because the property was mortgaged, Your Lordship, with the Meghalaya Rural Bank, so it is the requirement from the
Mortgage
bank
by whom? By you?
by my deceased father, Your Lordship. Now I wanted to.
Now you have inherited that property.
Yes, Your Lordship.
Where is that document of inheritance? There's a will.
Your Lordship, the legal heir have made an no objection certificate, Your Lordship, because initially they were supposed to register the property in the form of deed of declaration, Your Lordship, which is at the NOC. It's at page number 27, Your Lordship, annexure 5. These are the legal heir, Your Lordship. So they have no objection.
Now, when your father bought this land, was it registered?
Yes, Your Lordship, it was registered.
Where's the registration?
It's at annexure 2, Your Lordship.
Age?
Page number 20.
Who's Balapang Kharchi? That's your father?
My father, Your Lordship.
He is deceased.
Deceased, Your Lordship. So
This
now
was done in?
it was registered in the year 2016.
Okay.
Yes, Your Lordship. Due to the continuous non-denial of the NOC, Lordship, I have placed an objection also before the Secretary of KHADC, Your Lordship, and similarly an objection was placed before this Imam Al-Liam. However, Your Lordship, till date nothing has been forthcoming, Your Lordship.
Where is the NOC on? This NOC is page 28.
Yes, Your Lordship. And now since the property was mortgaged, Your Lordship, I had the
Did they reply? But why you need an NOC?
Your Lordship, from the bank, I was told
So
that
why NOC do you need from the Darbar now?
for registration in the form of deed of declaration.
You need an NOC
Yes,
from the
Your
Darbar now. Where does it say that?
Your Lordship, from what I was instructed by the bank, that because the impanel members or lawyers from the
Who's the impanel lawyer? Bring him here.
I was instructed by my
Which
client.
bank is this?
Meghalaya Rural Bank, Your Lordship.
Which impanel lawyer says you need NOC Darbar to this deed of declaration?
I am not aware, Your Lordship, but that was I was
No,
instructed,
you
Your
see,
Lordship.
the thing is that, see, you're registering before sub-registrar, correct?
Yes, Your Lordship.
Now you have shown that your other siblings have no objections.
Yes,
You're
Your
registering your land with your father,
Yes,
correct? And what role does Darbar have?
Your Lordship, since the registered deed is already with the bank, Your Lordship, so now for the for re-registration in the form of deed of declaration, Your Lordship, the bank requires that some kind of NOC from the Darbashnong, Your Lordship.
What is this? Who's applying for the state?
It's not the state. Your Lordship.
I'm preparing for this council.
We don't understand this.
Actually, the documents is still lying with the bank.
So you made the bank party?
No, Your Lordship, because the main issue here is with the respondent.
No. Why respondent? Why are they concerned about the NOC? Bring the bank here. Impute them.
All right, Your Lordship.
Otherwise, it's incompetent, your petition. They are the people whose the papers lying with them.
Yes, Your Lordship.
Now, why are you dragging this council for what?
Because I have
You
placed an
council?
objection, Your Lordship, with this
What did they
council.
do?
They have issued clarification, Your Lordship, from
They have
the.
made a complaint to us, so we have issued a clarification. We have sought a clarification from the Rambashnong of Nongra.
Who's this chief manager? You bring them.
Yes, Your Lordship. I'll
You amend this
necessary
petition.
steps. Yes, Your Lordship. I'll take necessary steps, Your Lordship, to amend the petition.
Otherwise, you know where you're seeking your relief from, and who are the people denying you your relief.
Yes, Your Lordship.
So you're asking the council what they'll do. Now NOC where it's necessary at all. Now from which what book of statutes or whatever, or guidelines have the bank said you need NOC from? You've already liquidated the loan.
Yes, Your Lordship.
Then?
And it has been remortgaged over the same property, Your Lordship. But
Over
now,
the same bank?
Yes, on the same bank. That's what, Your Lordship. Now the bank has provisionally allowed, because for remortgaging the property.
Your father took a loan.
Yes, Your Lordship.
Against and deposited these title deeds, correct?
Yes, Your Lordship.
Now you have that. You already liquidated that loan. You have liquidated it.
Yes, Your Lordship.
You repaid the entire amount.
Yes, Your Lordship.
Now you've remortgaged the land again.
Yes, Your Lordship.
For what purposes?
Because I've taken a loan over the same property, Your Lordship. So now.
So you liquidated the loan.
Yes, Your Lordship.
With the new loan you took?
The new loan, but then since the Dobashnong did not give me the NOC, Your Lordship, the bank had provisionally allowed me to remortgage the property.
No, why does they need the NOC from the Darbashnong? On what premise?
I'm not sure, Your Lordship, because I was instructed from my client that the bank requires the NOC.
Who's the lawyer, panel lawyer, who has given you this advice?
Not the lawyer, Your Lordship, my client itself told me that the bank requires that.
Strange. Yes. Your name is Malingyang.
R.S. Malingyang.
Yes. Please consult 1 week's time to obtain instructions. You impede the bank also.
Item number 3.
Wait, please, Your Lordship. Your Lordship, I pray that this matter may come up at the end of the board, Your Lordship.
No, let's see Mr. Pathak. What do you want, Mr. Pathak?
At this stage, I was paying for notice only.
Let me take notice. But does this case deserve notice at all?
My lord, the question is that these people, they were discharged from service under Rule 26. Their colleagues who preferred a writ appeal, they were reinstated. But then these people, they did not prefer a writ appeal. So
when were they discharged from service?
My lord, in 2016, 15 March 2016.
Now they're trying to get back their pension. What are they trying to get back now?
We are now saying that since you have paid us salaries till 2016, recently in 2024, from 1st of, my lord, January 2016, the 7th pay commission had come in. So my final pension is to be now revised as per the 7th CPC case.
Mr. B. Pathak issue notice. Ms. Young, correct? Present by Dr. N. Modi can accept notice on behalf of all the respondents. Correct?
Yes.
No further notice required. List the matter after 3 weeks for accurate instructions. Yes.
Item number 4.
What is this?
May I please, Your Lordship? This is an tender matter, Lordship. I am the petitioner in this case.
Yeah.
Lordship. So I am challenging, Lordship, here page number 83, technical evaluation matrix.
You're challenging the technical bid.
Technical bid. After finalization.
What tender is this?
This
you
tender,
please apprise the court if
yes,
we don't know anything
yes,
yet.
Lordship, I am the petitioner in this petitioner, and I am providing security service for to various institutions, and I am providing service to NIGRIMS since 2006. And my last contract work order was issued in the year 2018. So I am on extension till now till 31st March 2025. Now, Your Lordship, last year another technical tender has been displayed in the JAM portal online, and for the new contract for 5 years. And I have participated in the bid, and I have submitted all my required documents as per the bid documents. Later on, Your Lordship, on this tender was finalized, and the technical after that technical evaluation on technical evaluation matrix, my total marks was reflected in the JAM portal, and there are 2 qualifiers First is respondent number 5, and I am the second qualifier. But when I have seen after perusal in the technical bit, I have seen that my marks is less than respondent number 5. Not only that, Lordship, but it is wrong calculation has been done.
How do you see wrong calculation? Now, technical searches, I mean, understand. Now, there was a tender floated in the GEM portal, correct?
Yes.
For providing security services.
Yes.
So, you've taken part in the thing.
Yes.
And then there's a technical aspect.
Yes.
And now you say that the results have come out. When did they come out?
So, Lordship, result date is not reflected in the GEM portal, but I have got a mail from Team GEM on 6 October 2024. That is annexure 6.
Showing that your score is lower.
Yes, Lordship?
Showing that your score is lower.
Yes, my score.
So, how do you challenge the score? On what basis?
On what basis, Lordship? So, Lordship, page number 84.
How do you see it's illegal? Yes.
So, yes, Lordship, I'm just saying. Page number 84, Lordship.
Yes.
Yes, point number 2B. Point number.
Documented remuneration policy.
Yes, financial strength, annexure 6A. Annexure
yes,
6A.
Point.
Point number 2B, that financial strength of firm bidder.
2B value? No.
Value of executing a single contract
yes.
for providing security service in a government medical college, government hospital, PSUs, state and central state corporation, reputed public listed, private listed. And Lordship, here for more than equal to 20 crore is marks 10. Lordship. For more than equal to 17 crore, to less than 20 crore, marks is 8. Okay. Lordship. And in this way, till 6 it is going on. It is their marking style, how they will give it, Lordship. Now I have a contract, NIGRIMS contract only, since 2006, and it is a single contract. And the experience certificate has been given by the NIGRIMS itself.
Why do you see the marking is wrong?
Marking wrong. I'm just explaining, Lordship. So it is 34 crore, more than 34 crore. Page number 92. This is experience certificate given by the NIGRIMS itself.
Yes.
It is written, this is to certify Messrs. Shishupal Security Consultancy and Service providing security service NIGRIMS since 2006 according to work order given dated 24 August 2018. Total invoice accrued till the last 4 financial years, March 2024, is 34 crore 31 lakhs 34,108.74.
Okay.
So, Lordship, that means my marking should be here. Number 1, more than equal or equal to rupees 20 crore is 10.
1 second.
Yes,
now,
Lordship.
the computation for the for this marks
yes,
is for
Lordship.
1 year or for the entire period of 2006. Now they written what's this cooperation reputed public? Okay, fine.
So,
for more than or equal to 20 crores, that means like for 1 year
So,
or for.
yes, Lordship, it is written here, value of executing a single contract for providing security service government medical college. And here the first thing is here that certified audited.
You want to say a
balance
single
sheet.
contract 2006 to 25?
2018. Since 2018.
Okay.
Since 2018.
Since 2018 you
2018
have
a new
34 crores.
Yes. It is given here in the experience certificate also, Lordship.
Okay. 21, 22, okay. Right.
So
what now? Okay, next.
So I should get here, he has given, they have given 4 marks to me.
Where is that?
It is here, 2B, strength to 2B, Lordship.
Coming back to 84
coming back
again.
to 84. Coming back to 84.
Where are the 4 marks? Oh, here, yes,
2B, 4 marks, and the respondent number 5 is got 2 marks. But it's okay, but I should get here 10 marks. Because one single contract. So it is till now I am continuing. I am on extension period till 31st March. So I am continuing till that. And NIGRIMS has given me the experience certificate for that. And I should get 10 marks, but I have got 4 marks here, Lordship. Then again, Lordship.
I mean 10's maximum maybe. The score is 10's a maximum or what? No.
But
you have to be given 10. If you just do a contract over
for more
20
than
crores.
for more than or equal to rupees 20 crore.
Okay.
So my
Okay, yes.
I got for I have 34 crores here. It is.
No, got it. Yes.
Yes. And now second point, Lordship. Second is 3. Page number 87.
Yes.
Page number 87, Lordship, 3B.
Yes.
Here, total number of average security personnel per year already employed for other organization for each type of services as marked for in the tender. So it should be like that. Marking scheme is like that. For per 200 security personnel is 5 marks, and then multiple 30 with 1 mark. Means if 30 is added, then again 1 mark I will get. So here I got 7 marks. But Lordship,
How much personnel do you have?
I have submitted the details of 9 clients. Page
9
1.
clients only with Negrims only.
Not Negrims. Other than Negrims also, total 9 clients I have given.
And what is your personnel strength?
Page number 101. Page number 101, annexure 7B. The details of all the clients I have given, Lordship. So these are the details with the total marks or total number of security guards with their experience certificate and EPF also in prescribed form I have submitted. And in the GEM portal, online portal I have submitted.
Yes, okay.
Then afterwards, then Lordship, now I have, when the result has been out, then I have asked for clarification, because Lordship, in annexure 6, 83, page 83, again 83.
Now who does assessment for this? For computing these marks and assessment, which
Lordship,
is the authority?
actually GEM, GEM is government e-market.
Yes, I understand.
Yes.
E-market,
So
yes.
assessment has been done like that they used to upload in the GEM portal. Later on, later on from the Negrims also they download and they calculate and they
So
appoint.
Negrims is bound now.
Yes.
Whatever now, who's the other person? They got more marks than you by how much?
The respondent number 5, he got 65.5.
And you got?
And I got 62.5. So Lordship,
So it's not confined only to that personnel, and the other marks you got less than them, that means.
I got less than them, but the calculation has been done wrongly. Lordship, I have asked the clarification from the Negrims, Lordship.
So you see, in 2 parts it's been done wrongly. That
Yes.
means in the average number of security personnel,
Yes.
and in the turnover of
Yes.
the establishment
Yes.
you give
Yes.
security for.
Yes.
So you should have got 10 marks there and you should have got 10 marks here.
Yeah, there 20 upon 20 I should get.
Yes, 20
3B 20 upon 20 as per my calculation.
Yeah, Dr. Mosika, what is this?
My Lordship, kindly comes to page 155, my lord.
Oh, why have you come so late? Why have you come so late? Yes. Why have you come so late?
Oh, I have come late, Lordship. It is not because in the first of all, Lordship, this is a marking system. So I should be confirmed from the department whether it is correct or not, or my calculation is correct or not. So that is why I have asked. That is why I have submitted one clarification. So clarification dated 10 February. No, this one. Just a minute. 9/10/2024. Page number 90.
Okay, let's hear him. Yes.
My lord, page 155, my lord.
Yes.
This is dated 10th February. This is the clarification given to them, my lord. I am just read para 1 of this letter.
Yes.
In the first paragraph of the letter, it is stated any single executed contract value for providing security service to any recognized organization equivalent to 20 crore or more is eligible for a mark of 10, and if equivalent to 17 crore more is eligible for a mark of 7. However, this statement is incorrect as the provision outlined in serial number 2B of the QCBS format specifies the following. Value of executing single contract for providing security service in a government medical college, government hospitals, PSUs, state and central corporation, reputed public listed private hospital, For more than or equal to rupees 20 crore is 10 by 10. More than or equal to 17 crore is 8. So this is the clarification given, my lord. And para 2 is average annual turnover 3 consecutive years in 4 years, so and so in the field of providing security personal services was considered. And then what is more important, my lord, is the number 3. The security manpower deployed at Dalmia Bharat Cement was not considered as it did not meet the eligibility criteria outlined in the tender document. The criteria states mandatory precondition of having provided services by employing an average 200 trained and qualified security personnel per year to government, public sector hospital, a reputed publicly listed private hospital, or a government organization public sector undertaking for 3 consecutive years within the past 4 years. Since Dalmia Bharat Cement does not fall under any of this specified category, it was not considered.
No, but then the thing is that they come back to that personnel business. They say they have 7 marks only, correct?
Yes, Lordship.
7 marks, 5 is for over 200.
Yes,
And
Lordship.
1 mark for 30 personnel over and above.
Yes.
How many deployed in negligence itself?
So what I'll do, I'll have complete instead of file an affidavit within a week, man.
Uh,
The matter can be considered.
Of course, just trying to understand, which way, whether court can interfere, or because if it's a technical bit done by an agency like this, tell whether, can we sit over a tender committee and say the marks are wrong or right? If there's arbitrary marking, then if it's glaring, then yes. If it's not, then if there's room for,
yes,
then anyway, you take notice now for now.
Lordship, actually, since
No stay order right now. Let him come after 1 week.
1 week will file it.
Yes, we'll take up the interim matter
Lordship,
for 1 week.
but there is high possibility that they will issue the work order.
When?
So there is meeting is going on, Lordship.
You should have come earlier, yes.
My humble prayer, Lordship, if stay is granted.
The clarification was given on
till
10th
1
February.
week, otherwise it may be extended.
Because I do
It
not
may
know
be
whether the
extended.
work order already issued or not.
Yes,
I'll
I
have
have. If it is till 1
your
week,
name?
let it be extended. Like Miss P. Roy, Miss Priyanka Roy.
Yes, heard MS Bureau Council Petitioner. Submission notice, Dr. N. Mozika,
124.
Senior Counsel. It's been accept notice on behalf of respondents number 124.
Well, sorry, but Jem, I didn't think I can represent 1, 3, and 4.
1, 3, and 4. Notice to issue to the remaining two respondents within 3 days. Stop. The grievance of the writ petitioner here is with regard to the technical bid marking. The grievance writ petitioner is with the writ petitioner was stated to be a agency providing security services for installation solutions. Grievance is with the marks awarded in the technical bid for providing security services to the respondent number 1. Negligence is respondent number
3
and 4.
3 and 4.
3 and 4.
3 and 4. Stop. It has been submitted that as per the prescription given in the tender document for the marking system, the petitioner, in spite of having requisite we can't call it, in spite of having requisite personnel and also having a contract over over 34 crores, has not been awarded correct marks. Next, the counsel for the petitioner submits that the marking in a technical bid is in error and has caused grave prejudice to the expectation of the grave prejudice to the business of the petitioner. He therefore prays at this stage that interim orders be passed, staying the award of contract to the respondent number 5, who has scored more than her in the technical bid stump. We have Dr. Mbozika appearing for the respondents 1,
3 and 4.
3 and 4. Has submitted that clarifications have been given to the writ petitioner, and also drawn attention of this court to a letter dated 10 February 2025. Is that? 2025, wherein he submits the reasons for the technical bid marking has been provided. So he, however, prays that we be allowed to obtain further instructions in the matter. So, having heard and counsel for the parties, it is seen that the entire dispute revolves around the technical bid assessment by the respondent number 4, who is not represented here today. Accordingly, this is the matter after 1 week for after instructions. The petitioner is to serve notice upon the respondent number 4, which is
2 and 5, my lord.
2 and 5.
2 is gem, my lord, and 5 is the
2 and
private.
5 by before the next date, wherein the interim, the prayer for interim orders will be taken up. This also.
One prayer,
Yes.
Lordship. This is one clerical mistake has been done in the in this file. Actually, the matter page number 9. It should be page number 10. Actually, we have to
Yes,
just to flip.
MS Bureau is permitted also to correct a clerical error that's occurred in page 9 in the pagination. Yes, this accordingly.
Item number 5.
May I please, Lordship? This is second round of litigation, Lordship. Lordship, petitioner was the employee of Garhill's Autonomous District Council, and he was released from service on the edge of superannuation. Lordship, however, released from service, his retirement benefit was not paid, Lordship, to the petitioner. His retirement benefit was not paid, and therefore he has filed a writ petition before this Honorable Court, and this Honorable Court has disposed of, Lordship. Lordship, judgment order is at page number 19, Lordship, Annexure 5.
19?
Yes, Lordship.
Yes.
Lordship, can we have paragraph number 3, Lordship? Paragraph 3, Lordship.
Yes. Paragraph number?
Paragraph 3, Lordship.
Yes. Respondent to petitioner man. First paragraph. Yes, only directed so and so. Some time with months, yes, is expected special amount should be for the first installment. Interest is okay. Now what do you want now?
Lordship, after this order has passed, respondent has failed to comply with, and thereafter I have filed a contempt case, Lordship. Contempt case was also disposed of, Lordship. Judgment order is at Annexure 6, Lordship.
Then what happened?
Lordship, retirement benefit was paid, but interest was not paid, Lordship. I was entitled to get interest from March 2020 till the date of issuance of check, Lordship.
Yes, Mr. D.
At the point of time, my lord, when the contempt was disposed of, that is on page 22. We have given them a check, my lord, of 20,76,698. At that point of time, they have not raised any objection. Whether now, my lord, they can raise this objection whether the interest, calculation of the interest was correct or not, my lord. And if it is, my lord, then they can file a civil suit, my lord, for claiming that money, my lord. Now, my lord, in the writ proceeding, my lord, can it be decided, my lord, from when it has to be calculated?
No, the periodically is undisputed amount, then the orders can issue. What is the amount due, according to you? I have written a petition that this amount has not been paid to me. No. If you say that 6% interest not paid a certain amount, then you should have given the exact figure in the writ petition.
Lordship, respondent has paid only interest for the year of 1 year, Lordship.
Have you made representation to them?
No, my lord, they have not made any representation to us.
Then the prayer and the writ petition is for payment of interest on payment of remaining interest amount from the date of entitlement to the date of making actual payment. What kind of prayer is this? We'll dispose it off. The writ petitioner is for this court in the second round of litigation, alleging that in spite of the orders of this court allowing interest as applicable at 6% per annum entire amount, the respondents have only partly complied with the same. Stop. A perusal of the writ petition does not disclose the exact amount which the petitioner is claiming or the period thereof. Furthermore, it appears that the petitioner has not even approached the respondents with representation with regard to the.
Lordship, I have mentioned in paragraph number 10, Lordship.
Or the amount.
Yes, Lordship.
No, not the amount, my lord. It is only the.
Yes, only has not even approached the respondents with the prayer for which he has come again for this court. Like Mr. SD has also submitted that no interference called for at this stage, and the petitioner has the liberty to make a representation which will be examined. Accordingly, this matter is closed at this stage itself, allowing the petitioner to file an appropriate representation before the response 1, 2, and 3 for consideration. Yes.
Much more.
On the same being filed, the matter shall be attended to expeditiously. Well, matter stands disposed this.
Daily list item number 1.
Yes,
please, Lordship. Lordship, the respondent herein is. We've come to settle a term of agreement.
What's the agreement? You people are still.
Your Lordship, I have no instructions of now, Your Lordship. The client are out of contact, Your Lordship.
They've never objected to
Where's the process? Where's the agreement?
We sent it to them, Lordship, but they've never objected to it. They're agreeing in signing it.
Understanding is there, Your Lordship.
Yes?
And then understanding is there, Your Lordship.
Understanding is there. We say that who's appearing for this council?
Lordship, I'm appearing for.
What happened?
Lordship, I've not received instructions for this matter.
For whom?
I'm appearing for respondent number 1 to 5.
Who's for number 1? It's council 1 to 5.
Yes.
No. The thing is that they said that they already reached an understanding. Agreement has been drawn up, which we submitted before you. So for approval, that's all.
So just seek instruction.
They have not submitted as yet to this council.
No, not yet, Lordship.
Why?
We are awaiting instructions from the respondent.
I have not received any instructions.
You're trying to run away from me also.
That's why, Your Lordship, I tried to contact, but I didn't get through, Your Lordship.
How do you pass orders then?
Lordship, this matter may kindly be referred to, say, mediation, Lordship, to expedite the process.
Mediation, if you already reach an agreement,
Lordship,
and you already finalize the agreement,
Lordship,
according to submissions made last time, that what remains only for putting up before the council. Then, what mediation? You already mediated by yourself.
Lordship.
Take down though it is early, it has been recorded in early orders that an agreement had been arrived at between the petitioner and respondent number 6, which was to be submitted before the respondent 125. Today, Mr. Inombri submits that he has lost contact with his clients and he has not been informed as to the progress of the matter. So, why can't you contact them?
I tried, Your Lordship. Even this morning also.
You can contact them? No.
No, Lordship. We can try, Lordship, if given its
This is a
opportunity.
matter, Inombri is allowed one more opportunity
Yes,
to contact
Lordship.
them, failing which the respondent have to appear personally before the court. Just after 2 weeks.
Should I have one suggestion also? Since the parties are willing to settle the matter, Lordship, my submission, Lordship, let this matter be placed before the mediation,
No question mediation, it already is agreed by themselves. What mediation?
so that the
Let him appear first, he's lost contact with the client. Even in order for mediation, where will it go? Yes.
Much obliged.
Item 2.
I am appearing for the respondents in this case, and we have filed the compliance affidavit.
You are Mr. Ashish Rai.
Ashish Rai, yeah.
Your Lordship, in my humble and respectful submission, Your Lordship, there has been no compliance. Your Lordship, they've stated in paragraph 10 of their affidavit.
Compliance affidavit, yes.
Please.
Yes.
Paragraph 10, Your Lordship, at page 3.
Yes.
Your Lordship, it reads that in this regard, it is submitted that a proposal for the regularization of the petitioner is being prepared and will be submitted to the ABC division on file shortly for seeking the approval of Chairman Governing Council of NELIT.
It's in the process of being complied.
But Your Lordship, in their in page number 5, Your Lordship, which is letter dated 18/2/2025, Your Lordship, at subclause 2.3.
Yeah.
Your Lordship, it states that with regard to the case of Shri So-and-so, Scientist C, since the matter has been decided by the Honorable High Court, therefore ABC Division has no comments to offer. NELIT may undertake further course of action accordingly. Your Lordship, after this, nothing has been done, Your Lordship.
When is this dated? 18/2 only.
Your Lordship, I
An
pray...
affidavit has been filed by the respondent, wherein you submitted that the orders in the process of being complied. This after 3 weeks before the orders, yes.
Obliged, Your Lordship.
Then Lordship, it will take some time. Otherwise, if Lordship second week of May, then it will be okay. Then I'll.
Okay. Second week of April. Yes.
May,
No,
Lordship.
April. You comply before then.
Obliged, Your Lordship.
Then last week after May, April, Lordship.
Last week April, yes.
Your Lordship, this
Please,
order
Ashish
is...
Rai undertakes that by last week April, full compliance will be achieved. Yes.
Lordship, my submission may come that it will take time for the regularization.
Lordship, this
We have
order is from
constituted the
22, Your
committee. Committee has given its report, and after
He's still working.
taking reports,
He's working, Your Lordship.
Right, okay. Last week of April. Yes.
Item number 3.
Obliged, Your Lordship.
Lordship, affidavit has already been filed.
5 and 7, who's appearing for 5 to 7?
My Lord, 5 and 7, there is some problem with the cost title, it seems so. My Lord, I have court has issued notice, my Lord, to the registry, saying that respondent number 5 is NHIDCL and under secretary is respondent number 7. But in the cost title of the petition, there is something different.
Lordship, we have filed with the correct address, Lordship.
No, what did Dr. Muthika say?
I'll just place this one. Respondent number 5 is shown as NHIDCL, my Lord, and number 7 is shown as Ministry of Road Transport. But the copy given to me is something totally different.
Oh, pardon. See, but this one number 7, he newly implemented the national, this is NHIDCL, National Highway Authority in the NHAI. And number 5 is Regional Director, BSC plus JV joint venture.
NHIDCL is not party, but court has issued notice. But that's why I was a little.
Huh? Nobody joined the listing. 1 second, let me just check the affidavit file with them service.
Or we'll verify from registry. Maybe for some mistake. Or...
This registry is mistake. Because 5 and 7 they were served on 8th March and 7 and 10th March, and this is 24th February. So they must issue another case, I think. What is this?
Well, it's the same case number, 124 of.
Exactly.
What is?
Dr. Mozika has first take down an affidavit indicating service upon respondent number 5 and 7. That is Regional Director Spina, so and so, and newly implemented respondent number 7 has been filed by the petitioner. Stop. Next part, Dr. N. Mozika, the learned DSA, however, has drawn attention to this court to communication to a notice dated 24/2/2025 issued by the registry of this court, wherein other parties who are not implemented in the present case have been issued notice and shown as upon 5 and 7. Registry to verify and place a report before this court by Monday. Copy of the communication is notice is kept on record. Yes.
Item number 4.
Lord, it's fixed for filing rejoinder, my lord. So I'm praying whether this matter may be fixed for hearing, my lord. In the meantime, I'll file the rejoinder. It's ready, my lord. I'm filing by 2 days' time.
Yes, this matter for hearing. Ms. Abdul Priest may be allowed to file rejoinder in the meanwhile. Yes. Prayer allowed.
Right,
Yes, also.
Item number 5.
Just take time.
Number 4 appearing today. What happened in inquiry?
Lordship, it's almost complete, Your Lordship. Some more time may kindly be given, Your Lordship.
Mr. Anishwar Island AAG submits that the inquiry is yet to be completed. It is that the matter will be set after 2 weeks to wait the outcome stuff. None appears for the number 4. MS Amaraman present have response number 6 and 7. Yes. Just after 2 weeks.
Apply, Your Lordship.
On so and so.
Item number 6.
One second.
Petitioner.
Yes. Yes. What do you want to say?
A development has happened in the case. The petitioner had come to the office gate, refused to sign the papers, have been incorporated in the draft affidavit and sent to the department. We should be able to file payment.
What happened? Why you refused to sign the papers?
No, I did not get in regarding the instructions.
Under your instructions?
I don't have any instruction regarding destiny because here only he was retired on 21st/5/2021.
Why
As
do you
assistant.
refuse?
If Lordship, if
You
there
don't
is
want
if
pension?
that statement is true, then we have no problem with that. We are coming only for
Let us file
releasing of
affidavit,
the.
yes.
Let them file it. They have,
MS, I submitted the part that the writ petitioner had come to office, but in fact refused to sign the papers. Stop. Mr. P. Samas praised him without appropriate instructions.
Lordship.
This after 2 weeks for affidavit and for instructions from
Lordship.
Oh, this for after 2 weeks, yes, for affidavit. File it.
Must press
You
Lordship.
get instructions also. It's true. Then you advise.
Yes,
Sometimes
definitely.
these clients don't understand. You advise them.
Definitely, I will. I will advise it.
Lordship. I'm praying for a week's time in Lordship to file my rejoinder. Lordship.
Third time?
Yes, Lordship.
Or fourth time?
Third time, Lordship. Week's time, Lordship.
But Your Lordship, my one small prayer is that Your Lordship, Superintendent of Police is required to be implicated in this case because the petitioner is under trial. So we do not know the status of the case unless he is implicated.
What is the matter about?
Because promotion and though he is reinstated, but he was not granting anything because
benefit and.
You can get the status. What's wrong?
Unless he's made party, Your Lordship, we have nothing.
You're involved in which case?
Lordship, it's 392, Lordship. IPC 392, Lordship. Not the real Lordship.
392, 506, 34 one cases we do not know the status of the case because Deputy Commissioner has already written to Superintendent of Police.
I've been informed, Lordship, that is on CC stage, Lordship.
But unless we know the status of the case, Your Lordship, he may be implicated in this case.
How will Deputy Commissioner can get the information? What is there? Have you filed affidavit?
Yes, already filed.
They will listen for hearing.
Lordship.
You are for rejoinder?
Rejoinder is yet to be.
Fix it for
Peace night can place allowed further 2 weeks time to file rejoinder. Stop MS Esbrashi to obtain status from the respondent number. DC's respondent number?
Respondent, Lordship.
Respondent number?
Still three, Lordship.
On the status of the case which is pending against the
petitioner.
Which court?
Court is not known, Your Lordship.
Judicial Magistrate.
Where?
Shillong.
Before the GMFC Shillong.
Item number 8.
Yeah, please, Lordship. Lordship, this matter, I'm appearing on behalf of respondent number 4. Here, Lordship, what in this case? From 1, 2, and 3, Lordship.
Yes.
Lordship, even I have not filed affidavit, but here, Lordship, what the petitioner has asked is to retain the boundary which is according to 1955, Lordship. Now the chief has denotified that one because with the increase of population.
Denotified that one.
Yes. Now that denotification they have not challenged, Lordship. So how can the prayer is to retain that boundary of 1955? I'd like to take your Lordship in page 92, your Lordship.
Who's appearing for KJDC? You're appearing, Mr. Naitang. You will file affidavit. Yes, page?
Page 92.
You haven't filed, you filed affidavit? No.
No, Your Lordship.
92, let's see, where is it?
Annexure 13.
Annexure
13, Your Lordship.
Okay. Yes. Yes.
This is the and he translated copy. So Lordship, in this
so where is saying 55?
The last paragraph, Lordship.
Important discussion. Yes. Now you're saying that they want the restriction 55 boundaries.
Yes, Lordship. Now on this they have not challenged, Lordship, before
Which
the
one?
EC regarding this, which I've pointed out. which the chief had denotified, Lordship. They have not challenged or before the EC or.
You haven't challenged this since 22. It's in the up and do like this is in here. Will not work anymore. Is set aside or recalled. This and you're asking for the same boundary 55.
Yes, Lordship. Here
Where's
the
prayer. Let's see. Where is it, Mr. Kriam? Where they made the prayer that for restoration of 55 boundaries?
Lordship, I'll just take that first the appeal filed by the petitioner, Lordship, before the estate committee, Lordship. Page 65, Lordship. Annexure 7.
Yes. Where's the prayer?
The prayer is that page 70, Lordship.
70?
Yes, Lordship. Second paragraph.
Okay.
Yes, that's the
So
main
this
crux
is
of the issue
rejected.
is this one, Lordship.
No, but when they filed it that time, that 22 letter was not existent. This was filed
Yes.
in 2nd March 21.
Yes, yes.
After this, then this 55 notification was done away with.
Yes, sir, because practically it's not feasible, Lordship. Out of that villages, 6 villages have come to place. And in one of the villages, in Wailoi village, the boundary has been confirmed in the year 1991, prior to the send of the Elaka Act. Elaka was sent in 2006, 1991 Act. Actually, let me file affidavit, detailed affidavit in Lordship.
Otherwise, see, what he says is correct. Then what are you going to do about it? You didn't challenge that order 22 order, why?
Your Lordship, the boundary dispute was still pending, Your Lordship, before the EC. We had filed a boundary dispute, Your Lordship.
Here, the tribunal has referred to the chief to align, Your Lordship.
Your
And the
Lordship,
Now the chief has said that
Not
55
feasible.
asking for that's been withdrawn. That demarcation.
yes, Your
That means
Lordship.
there's no demarcation as yet. There has to be fresh demarcation. Then.
Yes, Your Lordship. They have to give the boundary regarding.
So they have to get a boundary. Your prayer is that in 1955, the demarcation of boundaries was done, but that was not adhered to later on, whatever happened. Then in 2021, he went for the executive committee saying that restore the boundary as per 1955. And the committee referred it back to the chief.
Tribunal refer back
Or
to
tribunal,
the chief.
sorry.
Yes, to the chief.
And then to the chief. And the chief,
Practically, it's not feasible because 6 villages have come.
and so the chief, he recalled the notification.
And
You take instruction or you have to challenge it. Even if you say it's pending with the committee, but the very fact you should have said that this is without a jurisdiction, then the 22 order.
Your Lordship, let them file their affidavit, Your Lordship.
He only whatever he said, he understood.
Your Lordship,
You mean
Your
the
Lordship, we
main
have
basis
filed-
repetitions go on.
Your
Yes,
Lordship.
Mr. BKM for phone number
4, Your Lordship.
4. Praise for 2 weeks time for affidavit. Mr. Naitang, you're not filing affidavit. You're filing. Similar prayer made by Mr. B. Naitang for 1, 2, 3. Just after 2 weeks. Otherwise, you take instructions.
Item number 9.
You have not challenged it, then that disables it petition.
9 also.
Whatever you're asking for, it's not there anymore. Whether it's an order might be illegal, might be wrong jurisdiction, but once an order is there, it's an order. Correct. This is that, yes. What is this?
You see, here it arises from the same proceeding, 3 villages in the same appeal before the EC, Lordship. But the same order we are challenged in separate, for separate village. In this item number 8, they have challenged only regarding Wailoi, but it's the same order which they agree. Now this for 2 more villages, item number 9. Same, but the EC has
Is it
passed
together then?
Yes, sir.
Your Lordship, Wailoi is in item number 8. Wailoi is a part of my village, Your Lordship. And in item number 9, they are neighbors. They are neighboring village, Your Lordship.
For the proceeding before the EC, the same, Lordship. Order agreed is the
Same
same.
proceeding.
Same proceeding, same order.
Then release it together then. One miscase for what?
Your Lordship, yes, Your Lordship. I have filed miscase, Your Lordship, in petition number 443 of 2024. Your Lordship, the respondent number, Your Lordship, this instant application is regarding respondent number 4 and 5, Your Lordship. They have vandalized and destroyed my forest land, Your Lordship.
When the boundary is with that village.
Your Lordship, the legal act are in annexure 1 and annexure 2, Your Lordship. Page
Oh, the
9.
miscase.
Yes,
Let
Your
me-
Lordship.
Let me take instruction, Lordship. Let's come for him.
Your Lordship, I pray
Whether
that
this
Your
area
Lordship,
falls under which village out of
Your
the three
Lordship,
villages, which village it falls?
till verification, Your Lordship, they are still continuing, Your Lordship, the illegal act.
Very difficult. How will resolve disputed facts? Yes, Miss Case number 49, 2025 in WCM 443. This application has been filed. Alleging that the opposite party 4 and 5 herein have engaged in destruction of forest land during the pendency of the case, which forest land of the petitioner during the pendency of the case. Mr. B. Kriam is allowed to obtain instructions on the matter. List together, list on so and so with other cases. Main case list together and so and so. Yes.
Your Lordship, I pray that the legal actions of the respondent number 4 and 5 may be stayed, Your Lordship.
What did we see? We have nothing on. What was on record before the court? Nothing.
Let me file affidavit.
How do you let them take instructions?
Yes, Your Lordship.
Yes.
Item number 10.
Is it expected that no, forget it. Don't write that thing. Create problems.
Obliged.
My lord, this is the case I am appearing for, my lord, that Lindo elector, 5 Lindo elector out of 6. Now, this is the case, my lord, where he has been placed under suspension. No, my lord, there is a sense of urgency, my lord. I have filed an application for vacating last year, your lordship. Now, this man, my lord, by virtue of this interim order, he is continuing without any darbar. No, Elaga is suffering, your lordship.
Lordship,
Elaga
Lordship
is
has
suffering.
heard the matter. Lordship was pleased to call for the records of from the district council. Now, the district council till date has not produced the inquiry report of the first inquiry report.
What's the matter about? I'm totally
This is suspension of the Sardar, Lordship.
Which Sardar? From where?
Nongpo Sardarship.
Loss of confidence.
He's been suspended twice on the same course of action.
Okay, yes.
There was a first inquiry report. He has been exonerated from all
Yes,
charges.
this is a loss of confidence statute very clearly provided. Loss of confidence will lead to, my lord. No, without darbar, my lord, can he function? And Elaga is suffering. My only concern is this, your lordship. Lordship, take it up, my lord. Other thing is inquiry and other thing, my lord. Second inquiry, third inquiry. But the fact is this, my lord, 5 Lindo electeds are before your lordship. We are saying we have withdrawn our support, your lordships. Now, can he walk, my lord, without a darbar? The Elaga is suffering, your lordships.
Yes, what are you doing?
The problem is the EC. Actually. The affidavit is lying there with the EC. So, because of the transition, that's the problem. Actually. I'm also helpless. Actually.
Lordship, there's a detailed order passed by Lordship on 1711.
In fact, I have the inquiry report
considering all
right
the
now,
aspects
so
of the
there's an affidavit with it also to explain certain things.
Mm.
So the exact list of electors which your Lordship had wanted clarification was 10. Out of 10, 5 of the Lungdaws are against the
I've expressed there.
Yes, 5.
So
But when
5
you
is
say
with you.
5 is with me, your lordship.
There is a loss of confidence. That's what I let it come up with your lordship decide it. There's loss of confidence. If the 5 has withdrawn, my lord, there is a, my lord, this is not a majority. And if there is a lack of majority, my lord, this will lead to suspension, my lord. And this is what is provided in the statute. So my humble submission, your lordship, take it up, my lord, next week.
Let the first inquiry report be placed before this court, lordship.
Well, for the purpose of vacating this two order, my lord, that is not relevant.
It is very much relevant. Your lordship has
I'll
passed an order
satisfy.
on
Lordship, take it
1711.
up. Lordship, take it up my application. I will satisfy why it is not relevant.
Yes. You have inquiry report with you?
Yes, yes, I have.
That's
But this was supposed to come with an affidavit to explain certain things. So, if your lordship wish to have a look at it, I can have a look.
It has to come and record.
Yes, yes, yes. The affidavit is lying to be.
Lordship, only my concern is
You've
this.
waited for so long, relax.
No, Lordship,
Ms. S. Marpan, Land Council for the respondents 1 and 2 submitted a due deed transition. The affidavit which is ready cannot be filed. Stop. Mr. S. Sen, counsel for respondent number.
Implicated respondent number?
For the implicated respondents.
7 to 11.
Expressed grief urgency and submitted has expressed the grave urgency of the respondents. Inasmuch as he submits, they have lost total confidence in the writ petitioner and the Eleka suffering as there is no presence of a regular darbar. In these circumstances, it is expected that the actor should be on board the next day. Feeling which, the next day, and the endeavor shall be dispose of the matter itself.
After a week, my lord.
After 1 week, yes.
Lordship, only the interim order may continue.
Interim order which will continue.
Item 11.
May it please your lordship. Lordship, in this matter we will need some more time, your lordship, for the affidavit.
Mr. Khanmopna, MSEB Pasa.
Received instruction, your lordship, bring for 2 weeks.
Maybe 3 weeks, your lordship.
Why was so difficult?
Your lordship,
what's the matter about?
My lord, it's regarding promotion, my lord.
From where to where?
My lord, it's regarding seniority and promotion, my lord, right from 2015, 2016, my lord. He was falsely accused in a criminal case, my lord.
He was discharged?
No, my lord.
Case still going on?
Yes, my lord.
Pending is going on.
2 cases, my lord. One in 2016 and one in 2018, my lord. Falsely accused, my lord, both cases.
Trespass and arson?
My lord.
Mr. Anishulai, AG with so-and-so, and Mr. Khanmopna for 5, pray for allowed for the 2 weeks time to activate.
It will be 3 weeks, your
Why?
lordship. I'm praying for 3 weeks, your lordship.
Okay, 3 weeks, yes.
Obla, your lordship.
Yes, my lord.
Item number 12.
May I please, your lordship, in this case, your lordship, I was instructed to 2 weeks time may be granted, your lordship.
Why no one appeared in this case?
Yes, your lordship, I do not know who.
Khabat never appears.
He is not appeared, so I am today appearing, so I am seeking 3 weeks time to file my affidavit.
Why 3 weeks time?
2 weeks not possible, your lordship, because after drafting it is to be sent.
Termination from service.
Termination?
Termination.
In one go, your lordship, I will file
In 1 week?
No, 3 weeks time may be given, and this is the only one time I am seeking time. That is the thing.
You won't take any further time?
No, your lordship.
MS Esmer Saji has undertaken to file the affidavit on behalf of the respondents within 3 weeks.
Much
He
obliged.
submits that no further time will be taken. Yes.
Highly
He is allowed to
much-
live over 3 weeks.
Much obliged.
See, you've given your word.
Yes, your lordship.
Then
I'll stick to that, your lordship.
3 weeks has to come.
Yes,
Yes.
your lordship.
13.
Mr. Khan.
This is a contempt.
It's appeared. Where's Mr. Yobin? Oh.
Oh, sorry.
That's what.
I'm sorry. In my cost list, this case was not reflected.
No, because he has not entered appearance.
This is a new case.
Yes.
Contempt.
Have you been instructed to appear?
Well, this on the last occasion I've mentioned that we have filed a SLP.
No, you have not mentioned this case at all.
Not right.
Now only 20. Now only ED cards were
Yes,
received and respond.
Oh, okay. Then I have no instruction, my lord. I'm sorry.
Also indicates that the sole respondent has since been served. So, Mr. P. Bin, who is present in the court, please will not appear instructions.
My lord. All right.
I don't think you've been given the brief as yet.
No, not yet.
Yes.
14.
Yes. 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 Two, 4, and 5. 1 and 3, Dr. Musica. You file affidavit.
Lordship, I am for respondent number 10.
You file affidavit.
No, I am seeking some more time, Lordship, to file the affidavit.
Okay, MSR Colony. You also want time? No. MSZ in country for response 2, 2, 4, and 5. MSR Colony for R6 to 8 and Mr. PD for 10.
10.
No, please.
Brief for allowed further 2 weeks time for affidavit. What about the other respondents?
Respondent number 9, we have submit affidavit of service of report, Your Lordship. Service has been completed, Your Lordship, on respondent number 9.
File affidavit service?
Yes, Your Lordship. That's fine.
When?
Yesterday we filed, Your Lordship.
Yes, MS Bison submits that affidavit also been filed, indicating service for number 9. As such, notes is complete all respondents.
Yes.
And this after 2 weeks for affidavits and for appearances for number 9.
Lordship, I have prayed my friend to supply me the copy of the.
That is between.
Obliged.
Supplementary list. Item number 6.
Who's being reply, Mr. Mishra?
Yes, my lord. Almost concluded.
I will not take time today. Your Lordship has given me 1 hour. Within that
1 hour?
1 hour.
I may take, you know, the Lordship has already given me that time, but I'm saying I'll try to complete within that or much before.
One request, my lord. In between, my colleague will be here because there is one part hard matter at 12:30 fixed today. So I will.
Yes, there will be.
But the reply, the counter argument by the knowledge advocate general, the promissory couple, the Lordship will see at the note submitted by the respondents. At serial number 10.
Yes.
They are saying 3 things, my lord. The first, they say there cannot be any promissory estoppel against law which permits respondent to create multiple CBW. This is one. I'll reply it, my lord. My submission would be that there is no law which permits CBW, multiple CBW, and that is clear from the provisions of the rules that and the promissory estoppel that I have placed before your Lordship. There, my lord, the policy decision that they have taken and reflected in paragraph 26 to 34. My lord, I am repeatedly submitting and relying on their promissory estoppel, which they have, my lord, put forth in paragraph 26 to 34, and they want to resign from there. So,
yes.
In my humble submission, there is no provision for creation of multiple CBW. This is one. Secondly, they say there is no promise held out by the government. Well, there are 2 decisions I have cited before your Lordship when I was leading the argument. One was Anglo-Afghan agency. Now, paragraph 16 of that, if your Lordship will see, it's very clear. It says that the promise need not be recorded. It should not be recorded like a part of the contract. But
yes.
If a representation is made, then the government is bound by that. And here in Anglo-Afghan, my lord, there was a notification saying that rebate will be granted on export of the woolen product, and that was done, and they wanted to resign from there, so they were held to their representation. Paragraph 16 will, my lord.
Yes, 1 second.
Paragraph 29, my lord, about Anglo-Afghan.
Yes. Paragraph 29.
we hold,
Yes.
paragraph 21,
Yes.
we hold that the claim of respondent is appropriately founded upon equity which arises in their favor as a result of representation made on behalf of the Union of India in export promotion scheme and the action taken by the respondent acting upon that representation under belief that the government would carry out representation made by it. This is promissory estoppel. What could be promissory estoppel? Now, promissory estoppel will not be that, yes, we hereby promise to give you this, give you that. For the purpose of law, my lord, to bind the government against their promise, their representation is enough. And I have shown, my lord, from their policy decision, they took policy decision, says that we don't want multiple bonded warehouses, but we want single entity. And they also say what are the benefits of single entity in paragraph 26 to 34 of their affidavit in opposition, which I have referred to your lordship. Now, your lordship, you see, rules provided for construction of godown. I have already taken, I don't want to take your lordship through that. And we spent a lot of money, my lord. Huge expenses were made. Now, once huge expenses were made, and my lord, the contract is for 10 years without any, my lord, making it to anything, without any curtailment or right to curtail. Normally, what happens when the contracts are determinable, it says that it will give you 3 months' notice and it will be determined. Here, my lord, there is, without any caveat, they say that this contract will be valid for 10 years and can be extended to 15 years. Now, this gives us some legitimate expectation, my lord. So that legitimate expectation cannot be taken away by breaking their promise.
That's the point, yes, legitimate expectation is. Legitimate expectation, yes.
Now,
Yes.
my lord, if your lordship remember, when I refer my lord Ashok Kumar Maheshwari's case, 1998 2 SCC 502. 502.
1998
2 SCC 502.
1 second. Yes,
Paragraph 16, my lord.
Yes.
So far as this court is concerned, it invoked the doctrine in Union of India versus Anglo-Afghan, in which it was inter alia laid down that even though the case would not fall within the terms of 115 of the Evidence Act, which annexed rule of estoppel, it will still be open for party who acted on the representation made by the government to claim that the government should be bound to carry out their promise made by it, even though promise was not recorded in form of the formal contract as required under 299 of the Constitution. To same effect, our decision in Century Spinning and Manufacturing Company Limited, if your lordship will see Century Spinning, my lord, and Manufacturing Company, it is, my lord, it is
very
there
famous
only
case. 1970.
1970, volume 1, 70, volume 1, SCC.
So, Mr. Mishra, it is para 15 of this Maheshwari judgment also. It's what's yes.
That was Lord Denning approved the decision. These are all started from blacks. I submitted from paragraph 8 on that day. I don't want to repeat it.
Yes. The black dictionary. Yes.
Just 4 lines are there in that paragraph in Century.
Right.
Century Spinning, 70, volume 1, SCC. Paragraph 12. Just 4 lines.
Yes.
If our nascent democracy is to thrive on different standard of conduct for the people, the public bodies cannot ordinarily be permitted a public body is, in our opinion, not exempt from liability to carry out its obligation arising out of representation made by it, by relying upon which a citizen has altered his position to his prejudice. Now, tomorrow they will say, okay, the government has, there is power, so in place of 1, we will have 44. So there will be 45 central bonded warehouses. There has to be some, my lord, rationale behind their action. And as I have said, my lord, the legitimate expectation will also bound them. They cannot take away. Then, my lord, the second point which I will reply, today I may run short of time, so and I will put.
So you finished a promissory estoppel. That's it.
Yes, because I have argued it
yes.
in my opening this thing, my lord, in detail, yes. And now this is the reply that I am giving.
Yes.
Now my lord, paragraph. Then, my lord, if your lordship will see the note of submitted by Learned Advocate General at serial number 5.
Yes.
Government is allowed latitude in economy and policy matter.
Yes.
Now the 3 decisions have been cited. I will.
But you already touched that last time on this TB Ibrahim. Oh no.
Madam?
Yes. No. Please continue. Please proceed. Yes.
Madam.
This
Madam,
is
first of all, is it a physical matter or economic matter? It is not, in my humble submission. I had shown your lordship paragraph 4 of their affidavit, which they have filed. And this is also in paragraph 23 of an affidavit, which was also filed there. I will refer only 4 at page 135. I have already referred it. Your lordship will see. AO dated 23 to 2024.
Yes.
Our writ petition, this present writ petition, 430.
135.
135.
Yes.
Paragraph 4, if your lordship will come. The next page, page 136.
Yes.
Additional CBWs would reduce any apprehension of favoritism and provide level playing field to all their stockholders. So is it a fiscal or economic policy, or they are trying to play to the gallery which was initiated in order to bring compromise? Level playing field. Now, I'll just show what is level playing field. If your lordship will see the dictionary, my learned friend will give, Concise Oxford Dictionary. In my opening argument, I have submitted that level playing field emanates from Article 19(1)(d), 19(1)(d), which says that everyone should get an equal opportunity. In a facet of Article 14. The lordship will see the next page, level playing field towards the end. Towards the end.
Yes, yes. Situation which everyone has equal chance of succeeding.
Has equal chance of succeeding. Now, yeah. They are trying to settle the matter between, my lord, the state and the international spirit. So where this question of level playing field will come? Because there has to be competition. And 2 lines I will submit, my lord, from Reliance Industries case, which I referred, paragraph 36 and 38. But on this point, this is 2007 8 SCC, page 1. Just 2 lines will be enough, my lord. Paragraph 36 at page 21, my lord, of the book.
Yes.
My lord, your lordship will come to Proceedings D.
Yes. Regularization.
in the world of globalization, competition is an important factor to be kept in mind. The doctrine of level playing field is an important doctrine which is embodied in Article 19(1)(g) of the Constitution. This is because the said doctrine provides space within which equally placed competitors are allowed to bid so as to subserve larger public interest. So it is level playing field can only arise when there are competitors, more than one competitor vying for a government contract or other government largesse, including servicemen. Then level playing field will come. So two things. One, they have taken this decision in order to achieve level playing field which does not exist. Now they cannot say that this is a physical and economic decision of the government. Now the decision I come to, the first decision is, which was cited by Learned Advocate General is R.K. Garg,
Yes.
1981 4 SCC 675. Your Lordship will get at page 68 of the respondent's compilation. 68. I may say, my lord.
Yes.
Even recently we have saw and we have seen, my lord, that government from time to time gives, my lord, the opportunity to those who are having black money so that they come up and the black money is brought in circulation. So this was one bond, and the bond's name is the Special Bearer Bond Immunity and Exemption Ordinance 1981, which was made into the Act. This was a physical thing. In that context, the paragraph which was relied upon by my learned friend was in this context, my lord. So out of context it cannot be. Your Lordship will just see paragraph 1 and 2. Paragraph 1 and 2.
No, 1 second.
These rate petitions, page 74, below. Paragraph 8. Paragraph 1.
Yes,
page
yes.
74.
Yes.
The writ petition raised a common question of law relating to constitutional validity of the Special Bearer Bond Immunity and Exemption Ordinance 1981 and the Special Bearer Bonds Act 1981. The principal ground on which the constitutional validity of the ordinance and the act is challenged is that they are violative of equality clause contained in Article 14 of the Constitution. There is also other grounds on which ordinance is assailed is constitutional as constitutionally invalid, as the President has no power under Article 123 of the Constitution to issue ordinance, and the ordinance is therefore ultra vires and void. We shall first deal with the latter ground, since it can be disposed of briefly. But before we do, it would be convenient to refer the relevant provisions. Now, Your Lordship will come to paragraph 2.
Yes.
On January 2, 1981, both houses of parliament not being in session, the President issued ordinance in excess of power conferred, in exercise of power conferred upon him under Article 123 of the Constitution. Now, Your Lordship, the relevant will be just the recital, third recital. This will be relevant.
And whereas?
And Your Lordship, this is part of the ordinance. And whereas it is expedient to provide certain immunities and exemption to render it possible for person in possession of black money to invest the same in the said bond. These are issued from time to time. This decision is not at all relevant, my lord, in my humble submission.
Yes.
Because there is no company done.
Not relevant.
Now, the second case which my lord, the learned Advocate General has cited is the state of MP versus Nandalal Deshwa. That's one. Page 120 of their compilation. Well, I'll just give the paragraphs, because if I start submitting it, we may run out of time. My lord, facts I will please. My lord, there were about 8 or 9 distilleries the matter relates to about 7 distilleries. And these distilleries, when they were producing country liquor, they were unable to meet the demand of the public. And the building infrastructure were very old, and every year government was spending lots of money on its repair. Then, the MP Distillers Association came forward and he says that you transfer these distilleries to us, and we will construct the building at our cost, and we will meet all the demands. The government agreed and gave them on lease. Now that was my challenge, and in that situation, the paragraph 34 was relied upon by Mr. Advocate General. Only in that context, paragraph 34 is reversible. The facts your lordship will get in paragraph 8. 8, I have just already said, my lord, this is what is contained in paragraph 8. Paragraph page 133.
Yes.
And then, my lord, will kindly turn to paragraph 17 and 19.
Para?
17 and 19.
17, 19.
17 and 19. 17 and 19. I'll place 19, my lord. Just 19 I'll place. Pursuant to the, your lordship got, my lord, at page 143.
Yes.
Pursuant to the letter of intent and deed of agreement, each of the respondents filed to elect approval of the state government, the new site at which distillery should be located, purchased the land at new site, started construction in the building for holding the distillery, and placed order for purchase of plant and machinery to be installed in the distillery. Some of the plant and machinery started arriving, and it began to be installed in the distillery. There was some dispute between the party as to how much amount each respondent 5 to 11 had expended by the time the first writ petition came to be filed by Nandlal Jaiswal. But it could not be seriously contested, and the considerable amount of money has already been spent by respondent 5 to 11 in acquiring land, construction of building, placing orders for the purchase of the plant and machinery, and taking other necessary steps before November so and so, when Nandlal Jaiswal filed first writ petition. There is evidence to draw that considerable more progress has been made by respondent number 5 to 11 in this directions by the time the second writ petition came to be filed by Sagar Agarwal. Each of them, on a conservative estimate, spent 1 to 2 crores rupees by the time Nandlal Jaiswal and Sagar Agarwal filed these writ petitions challenging the policy decision dated so and so on filing of these petitions, and application for a stay was made and was rejected. Rest not relevant. My lord, in these facts of the case, paragraph 34 at page 159 was placed by my learned friend. This he has already placed, your lordship has noted, I need not place. But my lord knows one thing very well. A decision is a decision for what it decides, and not what may flow from it. So the fact of the case is very important, and the fact of this case is entirely different. It doesn't, my lord, suit in or fit in to the present circumstances of the case. Therefore, this decision is also not helpful. Then, my lord, TV Ibrahim case was cited by my learned friend, my lord, 9, which your lordship will get at page 110. 110. My lord, I need not refer even this, because the facts are glaring. My lord, the person was running a bus station from a particular place. That place were inconvenient for the public. There were complaints, and then efforts were made to shift the bus stand to somewhere else. Now that person comes and says, my fundamental right is violated. So when the court says your right to run bus stand is not violated, what is What is done is by the government is that bus station is being shifted to other place. It will be shifted and you continue. And it happens everywhere. I think your lordship will remember when ITBT, the interstate bus terminal, was constructed in Guwahati. From Paltan Bazar, all these bus stands were shifted to the highways, and there were repetitions here. So, my lord, this case is of no importance. It doesn't fit in, my lord, to the scheme of our case, because here the bus station stand was being shifted. In that context, the paragraph which was submitted by my learned friend can be only in
Para 16.
My lord,
Para 16 was quoted by.
Para 16.
Yes.
Para 16.
Was quoted by the Advocate General.
My lord. Now, my lord, the next point is on the premature writ petition.
Yes.
Is that serial number 6. Now, my lord, as I submitted, we have come against threatened action, and therefore it is not premature.
Yes, that you already submitted. Yes.
Yes, I have already submitted. And my lord, I have placed, my lord, the decision which says that in case of threatened action, the aggrieved person need not wait for his rights to be infringed before he comes to the court. He can come before. That's very clear. But learned Advocate General, my lord, has relied upon 2 decisions. And both decisions are absolutely wholly irrelevant. The first is, my lord, Manish S. Pardasani, 180 of the compilation given by the state, 2019 2 SCC 660. They relied on paragraph 65 to 67.
Yes.
Now, my lord, the facts of this case is, if I can just tell, my lord, there was an FIR against a shopkeeper. He was dealing in the excise items. So the shop was sealed, and he was issued a show cause notice that why your license should not be suspended or revoked. He has shown, my lord, cause. Then the deputy commissioner, the collector exercised, my lord, he allowed his plea, my lord, and he just imposed some fine. Now, the superintendent was not satisfied, and he has filed an appeal before Commissioner Excise, my lord, stay. Now, he thought that Commissioner Excise is biased against him, and therefore he filed a writ before the court, my lord, saying that we apprehend that the Commissioner Excise will not decide the appeal in our favor. It was a pending appeal. This has nothing to do with the present case. I'll just place the very small paragraphs of the facts. Your lordship will see paragraph 4, and I will start from. On 10/8/2018, at page 182, my lord.
Yes.
On 10/2018, an FIR was registered by the State Excise Department against the appellant inter alia for undertaking home delivery of the liquor on telephone orders being placed and for commission of other offences punishable under section so and so. FIR law. This led to sealing of the appellant's liquor shop on 11/8/2018 by the State Excise officials. The collector excise issued so cause notice on 27/8/2018 to appellant, setting out therein the breaches of license conditions and violation of certain provisions of the MP Act. The appellants were directed to show cause as to why their license be not suspended or cancelled under section 54 of the MP Act. The appellant filed their show cause reply. On 5/9/2018, the collector excise, after hearing the appellant, passed interim order and directing de-sealing of the appellant shop on condition contained therein. The Superintendent of Excise, Mumbai, felt aggrieved by order dated so and so of the excise Collector Excise, and filed an appeal before Commissioner State Excise Maharashtra, being appeal number so and so. Then 10. The Commissioner Excise, in exercise of her appellate power on 5/9/2018, stayed the operation of the interim order dated 5/9/2018, passed by the Collector Excise. The appeal was pending for adjudication before the Commissioner Excise. On 10/9/2018, Collector Excise passed final order whereby directed the licensee to pay 50,000 as compounding fee for breach of committed by the appellant. Aggrieved by the order dated 10/9/2018, the Superintendent and Excise, State Excise filed an appeal before Commissioner Excise challenging the validity and correctness of the order dated also passed by Collector Excise. The Commissioner State Excise by the ex parte order dated 17/9/2018 stayed the operation. So there were twice Commissioner Excise, my lord, interfered against the shopkeeper. Then what they did, paragraph 17, if your lordship will come to. The two writ petition, so and so, challenge was mainly on sealing order dated 11/8/2018 passed on the oral direction of the fourth respondent to the second respondent in so and so. The second order dated 17/9/2018 passed by the Commissioner State Excise. The other reliefs claimed in the writ petition were essentially and consequential to the main relief. The appellant challenged the aforementioned order on legal ground, including violation of the statutory rule which requires a hearing being granted to the license holder. The writ petitioner also contended that conduct of the Commissioner State Excise give rise to apprehension of bias. In these circumstances, a prayer was made for the appellant to be heard by another officer of equal rank. But in these circumstances, this order was passed. How can you come? The appeal is pending, it has not been decided. Simply you say that the commissioner will be biased and therefore my case will be transferred. I'm sure your lordship must be dealing with these kind of cases. Right. On that it cannot be, and 65 to 67 was cited, my lord, referred by the learned advocate general. 65, I need not, your lordship has already gone.
Yes,
So
up to 67 years.
Yes. 65 is important, 65 and 67. 66 and 67. Now, the next decision which was filed, my lord, by learned advocate general was Mahadev versus Soban Devi, 2023, 10 SCC, page 170. My lord, this is on noting of the file. My lord, it is settled law that if there is noting on the file, that will not give any cause of action to any person, because noting in the file is an expression of opinion by different officers through which the file moves, unless there is an order. Now here, there is no noting on the file. The state comes up before your lordships and say that we have taken decision to create more CBW. Is it noting on the file? In my humble submission, this case is not at all applicable to the facts of the present case.
Mahadev.
Mahadev versus Soban Devi. Here, my lord, paragraph 3 and 4 of the affidavit at page 135, which I have referred, that is enough, my lord. There is no noting on the file, and decision is taken, and they are saying on oath before your lordship. Can they go back and say that there was no decision? I hope I'll be able to complete. Now, the next point is sub judicata. Your lordship will see paragraph section 10 of the CPC first.
Yes.
Section 10 of this CPC method. Stay of suit. No court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in the previously instituted suit between the same parties, or between the same parties under whom they or any of them claiming litigation under the same title where suit is pending in the same or any other court in India having jurisdiction to grant relief claim in any court beyond his limit. So, if it is directly and substantially in issue in the subsequent suit, then the suit will be stayed. Now, my lord, I have already referred to my affidavit in reply at page 43. 43. I'll not repeat, I'll just show. I have quoted the paragraph where relief is claimed in that case, which is pending before the division bench. There, the issue is constitutional validity of the 2022 amendment rules, both excise as well as bonded warehouse rules. Whereas, in the case before your lordship, what we are asking is, we are asking, my lord, that they should be restrained from implementing their decision because their decision harms us. And those decisions are against their own policy decisions and the rules. So where the issues in before your lordship is not an issue in the division bench. From the prayer your lordship will see. And the decision that has been cited is in my favor, my lord. It goes against the state. It goes against the state. The decision is SP JAR to page 193 of the paper book, 2013-4. 2013-4.
Page or paper book?
193, my lord.
SP JAR.
Yes, yes. My lord, here, not one, 3 suits were filed and it was overlapping, but the issues were not directly and substantially same. I'll just place, my lord, paragraph 2 and 3. The plaintiff claimed to be owner, lordship Butler.
Yes.
Page 194. Plaintiffs claim to be owner of the building known as Hanu Manor, situated at so-and-so place. According to the petitioner, in one of the flats of the said building, measuring so-and-so, situated on the second floor, defendant's father, Sri so-and-so, was inducted as tenant on the monthly rent of 355. The petitioner filed a suit for eviction of the tenant premises against the defendant being so-and-so, before Spong Causes Court on 6/11/2004 on the ground of bona fide requirement for said acquisition and acquisition of alternative accommodation by defendant. The plaintiff therefore filed another suit, so-and-so, on the same day in the small causes court for eviction of the defendant on the ground that non-user of several years before institution of the suit. Plaintiff during the pendency of these two suits chose to file yet another suit bearing number so-and-so for eviction of defendant on the ground of non-user for continuous period of not less than 6 months immediately prior to the institution of suit. So the same person filing 3 suits between the same party. Then, my lord, the third defendant filed an application on so-and-so date for a stay of the hearing of the suit in disposal of the till final disposal of the first and the second suit. The defendants made aforesaid prayer inter alia stating that parties in all the 3 suits are same and also the issues. It was further about that the subject matter of these suits are one and the same. According to defendants, since the matter in issue in the third suit is substantially in issue in earlier 2 suits, the trial of the third suit is liable to be stayed under the hearing and final disposal of the previous instituted first and second suit. The plaintiff filed reply objecting so-and-so prayer, then prayer is there, then my lord, your lordship will come to paragraph 12, which was relied upon.
Yes.
And this goes against London Advocate General Schools. It is page 198. As observed earlier, for application of section 10 of the code, the matter in issue in both the suits have to be directly and substantially in issue in the previous suit. But the question is whether the matter in issue what exactly means. As in the present case, many matters in issue are common, including the issue as to whether plaintiffs are entitled to recovery of possession of the suit premises. But for application of section 10, kindly note, my lord, but for application of section 10 of the code, entire subject matter of the two suits must be same. The provision will not apply where a few matters in issue are common and will apply only when subject matters in controversy is same. This is enough, my lord. This is enough. This goes against them. And here, my lord, the petitioner is a different person. I am not the petitioner there.
Yes.
So, my lord, this Asmin Jal is,
yes,
it doesn't support, rather it is against their plea. Now, my lord, they say they made another prayer that no interim relief can be granted if the main challenge is pending. This is 8 of their note, paragraph 8. Now, my lord, I don't understand this point, because the High Court rule separates the jurisdiction of the single judge and the division bench. Single bench and the division bench. Your lordship, as I said, exercise your lordship's power under 226 as authorized by the High Court rules. And your lordship will take our writ once again 430, my lord. Page 24, my lord. Page 24. My lord, got it?
Yes. Prayer.
Prayer. Now your lordship will see, this is our main prayer. Now, how can prayer made by the plaintiff in 186, which is pending before division bench, be referred to as our prayer? And we don't know. We have made this prayer and then we are making an interim prayer which is relatable to these prayers, A and B. Therefore, my lord, this is a very curious point that has been taken. Main and interim, both are before your lordship. Now, my lord, the last point, hopefully I am on time.
Yes.
The last is, my lord, that we don't have fundamental right. I have submitted, my lord, that we have fundamental right under Article 14, and the government cannot act arbitrarily. Government and its officers. Because, my lord, if the officers see that their boss, their employer is working, my lord, arbitrarily, then they will act even more arbitrarily. And I am sure, my lord is aware with the arbitrariness, the example of arbitrariness which was given at when Saddam Hussein was, my lord, at the heads of affair in Iraq.
WMDs. WMDs. Yes, no, please continue.
No,
yes.
My lord, I'll just say this. My lord, Saddam Hussein's daughter was studying in a university. She wanted a particular professor to come and take her tuition. So she asked Saddam Hussein, he said, no problem, it will be arranged. Saddam called one of his general and said, get that professor. And then he forgot. After a week, the doctor reminded him, where is that professor? Oh, I have asked the general, let me call. He called the general and he says, General, what happened? I asked you to get that professor. He said, yes, sir. We got that professor. He confessed his guilt and we executed him. So this is the arbitrariness of a monarch, autocrat.
Yes.
So in my humble submission, my lord, I will just sum up. In my humble submission, the state cannot go back on their policy decision without equally good reason. And their policy decision they have stated in paragraph 26 to 34 of their
Affidavit, yes.
Filed before the division bench, which I have already referred.
Yes.
Secondly, they have framed the rules, because my policy decision, how the policy decision will be implemented, it will be implemented by rules or by an executive order under 162. So, my lord, They have already amended rules. The rules were amended only to bring CBW. And there is no other entity which authorized my lord to import and distribute to the bonded warehouses. Therefore, my lord, having done this, and I have, my lord, acted on their representation, and I have altered my position, they cannot go back on their promises. And my lord, it will entail, my lord, it will affect, or it takes away my legitimate expectation.
Yeah.
I have spent so much money. I have legitimate expectation that I'll be allowed to run it for 10 years as per the statute. Statute, Your Lordship will remember, particularly I said this 10 years. Rule 44, my lord.
Yes.
It's for 10 years. And my lord, it is also mentioned that it can be extended to 15 years. That was my legitimate expectation. How can they take away that? So therefore, my humble submission will be, they should be restrained. If they've already taken decision, the decision should be quashed, and then they should be restrained from, my lord, having multiple CBW, unless they make they take a proper decision, make a proper thing, and they don't, which does not violate promissory estoppel and legitimate expectation, which they cannot do. 5 years have already gone, another 5 years they should wait.
How many years is gone now?
This is my
third year.
5 years.
5 is already gone.
5 years gone.
Yes, then you usually submit your written submissions, but because it's very long. Yes.
But only one thing. Only one thing. Page 182 of the writ petition, my lord, we have indicated how we have changed altered our position, my lord. Page 182 of the writ petition, how much we have.
What position you altered?
How much we have invested in. There's a table provided, it's page 182.
You spent 4 crores 50 lakhs.
My lord, we have outstanding amount receivable from customers is 53 crore rupees, my lord. Bank loan is 24 crore rupees.
No, total is how much? You have stock in hand of 58 crores.
58 crores.
Total is 152 crores 41 lakhs 13,149.
And moreover, my lord, page 186, lordship kindly sees, my lord, how the revenue is jumped up, my lord, after the central bonded warehouse. Page 186.
Yes.
Para G, lordship.
What before that was how much?
180 something, but now it's jumped to 325.
That time before CBW. So they would increase it further now.
My lord, one thing, my lord, the thrust of the submission is, if I have understood correctly, my lord, is that under the Act, under the rules of excise rules and bonded warehouse rule, I do not have power to create more than one central bonded warehouse.
See, no, it's not only that. The argument has advanced into other areas with regard to, even the question of legitimate expectation, the question of, like a promissory estoppel.
Yes, my lord. Briefly, in 2 minutes, my lord, I will your lordship is aware of the basic premise that your legitimate expectation, your promissory estoppel, all these things will not stand against the statutory provision. A statute will override all these requirements, my lord. I have placed those judgments also, my lord. Because if the law permits me to have...
Well, statute is subject to interpretation, Mr. Advocate.
No, so therefore, if your lordship will interpret...
Like even I submitted that even reading down of certain provisions, because there's plural, singular, anyway, those are other things, yes.
If your lordship...
So now there are some clarity now, the court has to devise a sort of a formula, you understand, where some clarity is there, that's the thing. We cannot have like at cross purposes, two definitions.
Yes, my lord, your lordship has to take a call. Under the Act, your lordship has to take a call. My submission is that, my lord, the Act is very clear. I can have as many bonded warehouse as I deem fit. There is no bar, my lord, under section 16, or even if I can show, my lord, even their own affidavit before the division bench, my lord, they say that we can establish as many bonded warehouse or as many central bonded warehouse. I have annexed that in my compilation, last annexer of page, this compilation. They have said so, because understanding, there is no confusion in the understanding, my lord. If I take their argument, no, only one bonded warehouse or one central bonded warehouse is envisaged under the act and rules. If I take the, my lord, then I have got 40 bonded warehouse under those section 16. Then if the argument is accepted, all those 40 bonded warehouses have to be discontinued because I do not have power. I can establish only one bonded warehouse, my lord. That is not the plain and simple reading of section 16. If your lordship will see one provision, my lord, of the rules only.
That one is you were advancing the argument regarding designated area. Designated, right?
Yes, no, designated is separate argument. First argument is, my lord, that I have power to establish more than one bonded warehouse.
Yes.
Second argument is that I have a designated area also supports my argument to the extent that I can have central bonded warehouse for a designated area. That in itself shows, or for whole of the state, that shows that I have the power to establish more than only briefly summarizing what I have understood, the eliminating arguments. And then the issue is that, my lord, if lordship holds that no, under the act there will be only central bonded warehouse or only one bonded warehouse, in my humble submission, it is not in terms of section 16 or even not in terms of the amendment rules. Kindly see that, just for the sake of, my lord, kindly see the amendment, my lord, of the excise amendment rules, my lord. That is, my lord, for the sake of convenience, I have given probably compilation of act and rules, your lordship will
It's
have.
already been given.
Yes, your lordship will see only 271.
Which rule?
I am citing amended that 15th October 2020 rules.
We don't have.
That is the part of your repetition. It is part of
79 of your.
it is part of your repetition, sir.
Page 79. I think.
Yes, page 7.
Amendment rules.
Yes, your lordship will see amendment 2. That is amendment of rule 3.
Yes.
Now, in principal rule 3 rules, in rule 3 sub rule 2, for the words bonded warehouse, the word central bonded warehouse shall be substituted. So the earlier term was bonded warehouse. Now we have central bonded warehouse. By invoking the provision,
so you can have 44 or 45 central
I can have,
bonded
because if it suits my because there are two aspects, my lord. One aspect is in law whether I am prohibited from having more than one central bonded warehouse or not. That is one aspect. If I am prohibited, my lord, I have a remedy to go to the legislature or to the rule making authority to amend the rules. Second is under, so therefore, if my submission is that if there is no bar, my lord, and there is no promise, my lord, what your lordship has seen, what promise I have made? You have made the investment, my lord. You have made the investment. At best, your claim will be claim for damages, and that is also barred by license agreement to which you have agreed. License agreement says.
You remember it.
Yes.
Okay. Now, what are points? Are there new things you want to say with regard to the replies given by Mr. Mishra? That's all.
Yes, my lord, there are new points which have been argued. I remember only brinjal example, my lord. No, so what I say is, for the sake of clarity, my lord, under the act I have power to do it, and there is no promise which I have made, my lord.
Again, and that's a promise. Now, see what Mr. Mishra has argued is that promise doesn't have to be implicit, explicit.
Yes, my lord.
Promise can be inferred.
Yeah,
promise
so now
is by the very action of.
I'm grateful, my lord.
How how we can infer.
I'm grateful for erudite argument. Inference.
Now you can glean from there.
Yes, my lord.
Your action itself.
They are trying to construct
the promise will come.
Yes, my lord. They are trying to construct the inference from conduct.
Like Lord Denning said, the judgment. No?
Yes.
Lord Denning said what?
Yes.
Lord Denning said it's a matter of honor.
Yes, matter of.
Suppose some action is done.
Yes, my lord.
If it's between gentlemen, so it's a matter of honor.
Yes, my lord.
If you have been.
No, so then the question which falls: Did we say that you will have only one central bonded warehouse throughout the state, anywhere in any of the tender document, license, anywhere? They are inferring something which is not there, my lord. They are because if you have made the investment,
29 of your affidavit.
in that I have said that right now we are happy with one central bonded warehouse. 5 years.
You file.
I will file, my lord.
Let him file.
Yes, my lord.
Submissions.
Yes, my lord. And kindly.
One case is repeatedly housing, my lord, that we have power to have more multiple bonded warehouse. Yeah, they had, and they had 45. Why did you reduce it to one? And now he is trying to justify.
So now the policy, what is being questioned is my policy of 1 or 44. If I have a power under the now policy also, I will.
Just give it
even policy,
yes, my lord.
Decision making process.
Yes.
Now, if policy has been
no, my lord. I come to the second argument. I bow down completely, my lord. I come to the second argument. If I have power, whether there is a justification for this policy or not. Your lordship has that the second part. Now justification I have shown more than one, and your lordship has seen that in excise and taxation matters, your lordships have always maintained arm's length distance.
Hands off, yes.
Yes, arm's length distance, my lord. In this matter. So I put my note, my lord.
When Article 356 was challenged in Rajasthan case, then my lord, the argument of the government was judicial hands off.
Yes.
Article 352, now your lordship will see.
No, 356 is dealing with subjective satisfaction. The question which falls in Asarbomai, but because I can't forget this, the 356, because when I was taking the civil services interview, the question which was put to me in the interview board, that you go in dark room and then in dark room I see the ghost and you don't see the ghost. So it is a question of how do you relate it to 356? When I was young candidate, I was thinking about so 356 I can't forget. That is why.
Yes, the matter on next week for
your lordship file for written submission. We'll file written submission.
Why?
We'll hand over to the court master. We'll hand over to the court master on Monday.
Monday will be too short because I will be traveling this week. So Tuesday, by Tuesday.
So sometimes for status one we don't fix the date, then it gets.
Wednesday, your lordship may have it by Wednesday.
This matter on Wednesday for submission, written submission by the parties. Yes, I think it will be required because it's traverse.
Article 19G, my lord, there are so many good issues which your lordship have to Article the scope of and that judgment should be a kind of landmark judgment.
Yes, there's other matters, are there?
Item number 7.
Thank you.
7.
Yeah, the Banihat Nasi, what to do?
We are praying for some other date, my lord. He was here, first of all this while.
I have stayed a lot
he
against
experienced a bit of discomfort in his health, so he left. My lord can have it next week, maybe my lord, Monday, Tuesday, whichever date, as per your lordship convenience. Since we have already halfway through.
Actually, this one, only Mr. Paul has given
I have to add something to Mr.
What's causeway? You know the causeway, right? Causeway, suppose the destination is here, point A, point B. So a causeway, like you might reach the same destination, but you take a causeway.
Going through the other way.
It's a causeway. And a causeway, there might be other things there. The only thing I think Mr. Paul is trying to take causeway and maybe arrive at a different destination. Two is the same in like the territory view of the court.
Destination is the same. Ultimately, destination is one and the same only.
You can't complete arguments, no.
I have no instruction.
Tactfully, yes. Anyway, okay. Mr. Yargudi, what to do? You can do it online if you're not here. On Monday, then please. We're going to complete it by Monday.
No.
Because otherwise, the court will forget again and then the judgment, it's.
But I'm having a similar prayer for item 23, Madam.
What's 23?
23. It's not connected with this electricity matter. It's a different matter, Madam.
Filling on behalf of the commission in Brennard. Yes.
You
Because
can
some
have it.
difficulty health situation on Monday. Yes. As a fixed matter. Yes.
23, my lord, can have it next week, my lord, any date.
Monday.
Hearing.
Okay.
Not
Saraswati Vishwakarma. Why? What about this?
Not praying for a date.
What's the matter about?
My lord, this matter is with regard to that electricity connection, my lord, where the state respondent have taken the money from me for installation of the electricity connection, my lord.
Mr. Sen was very. He had some urgency. Where's Mr. Sen? He has a lot of sense of urgency. He was expressing that day.
Actually, today he's not available.
He wanted the matter to be heard.
Yes, my lord. For 1 week, my lord.
Let it be joint prayer, my lord.
Okay. 1 week is. Otherwise, he was mentioning that day, correct?
Yes, ma'am.
I'm not aware.
No, he had met when the matters is last. Yes. Other matters who are ready with
Item 15. Hearing 15.
Please, Your Lordship. Lordship, 15, 16 and 17 are connected matters, and on 17, Sir Kipol is appearing.
15?
16 and 17.
After 1 week then, yes.
Lordship. 2 weeks, Your Lordship.
Alone.
Lordship, 2 weeks. 2 weeks, Your Lordship.
Why 2 weeks?
Lordship.
Just like that. No, it's only after 1 week, yes.
Oh, Lordship.
21.
Where's Mr. Shubhit? You're there, Mr. Paul's there also.
Lordships.
Where you are, what's the matter about? Where's the petitioner?
This is
MSE, what's this? Salam.
This is regarding Shillong College, Your Lordship. About teachers,
Where's the petitioner?
assistant professors.
After 1 week, okay. This is UGC is there.
UGC is there.
No, it will matter after lunch.
Lordship, urgency was being expressed by Mr. Sen only on the last
Yes.
date.
So he's not there.
After 1 week, none appears out of petitions matter for 1 week, yes. He was there in the morning.
26.
Was could won't be there tomorrow. I mean, until 12 only.
My lord, this is the same salary matter, my lord, Ruchi Kumari, my lord, where on my...
committee is not here again.
My lord, this...
The managing committee is required.
My lord, kindly note at the conduct of this managing committee, my lord. They are the one, they say that there's a connected matter with the other... This,
Who was that? SK Hassan? No.
No, my lords. Mr. Pandey.
Pandey. Was
Where is the Pandey?
Lordship, I have not seen him today.
My lord, there are so many orders, my lord, at least three occasions
no,
orders.
Call them up. The other matters connected to this one.
They have just taken adjournment in the other matters, my lord.
Today?
Yes, my lord. Item number 16.
15, 16, 17.
15 to...
In one of the matters, Mr. Yopen's client is the respondent. We had challenged her appointment, Lordship. In item 15 or 16?
Yeah. 16. Item 16, my lord. So
that's been adjourned.
That's just got adjourned, my lord.
Item 17.
And this item is connected also Ruchi Kumari.
Yes, my lord. No, that, my lord, but this, as I was submitting, my lord, salary matter, my lord, it's not connected with the challenge to my
Even
to my
then, it'll have an
candidate.
impact, whatever.
No, my lord.
Salary, you might take it differently, but then it'll affect somebody, it'll pinch someone.
No, who?
And the other person's pinch is already on board in other cases.
My lord,
Yes.
We are the petitioner, we had challenged her appointment.
they are the petitioner who was unsuccessful in the interview and subsequently they came to challenge. When they took the interview, they didn't even say anything.
Managing committee in the other matter?
Managing
Mr.
committee.
Mr. Pandey.
It's very confusing. If they don't appear, then we'll do
My lord,
party.
yes.
We'll
But-
pass orders.
My lord, the only thing is, my lord,
To your detriment, Mr. Naupir, what to do?
Which we can come next week.
because
1 week, yes. We'll listen Wednesday.
Wednesday, my
Concerns
lord.
the same managing committee, Lordship. Same school.
203, 26. As a fixed matter is.
My lord.
My lord.
All right.
27.
27 also, Mr. Paul not here. Mr. Krem ready with the matter, I think. Yes.
Next time, Your Lordship will be granted.
This is what matter was about. Sukuman Tang, 76.
This is really ICT's promotion of social welfare.
Supervisor to CDPO, Your Lordship.
You won't do it in the second half?
Lordship, Senior Counsel is letting us in this matter, Your Lordship.
After 1 week, okay.
Highly obliged, Your Lordship.
PT Sama, 28, yes. Ready?
Lordship, this is sorry, Lordship. Very small issue because I'm going to accept whatever money the state government is giving because this is regarding contract matter where I have claimed for 47 lakh. They're saying that out of that they have paid some money.
So last time had come up.
And then they are saying that I have to get it only 25,000.
The work was, he was given a completion certificate, Your Lordship. However, after inspection, it was found out there were some anomalies in the work, inconsistencies, Your Lordship. He was asked to rectify the work and then which he has not done till date. But however, Your Lordship, we've already paid him 33 lakhs, 57,000. Now the remaining balance is 25 lakhs, 53,323 rupees.
Which you admit?
Yes, they have admit. I have in my region also. Yes,
Para 10 of my affidavit.
Para 10 of the affidavit, para 3, Lordship. There is no quarrel. I will accept that amount, whatever their state government is paying. The remaining balance 25,000.
Oh, yes, we have already heard this matter.
Yes.
Mr. P.T. Sangma, on receipt of the affidavit filed by the state respondents, has submitted that
I put it in my rejoinder also.
Accepts the
amount. Yes.
The statements indicating the amounts due given at para 10 of the affidavit.
Yes, para 10, para 3.
Stop. He therefore prays that the matter may be closed at this stage itself. Next paragraph. Ms. Ailungma, Learned Counsel for Learned GA, has also submitted that though the petitioner had claimed rupees 74 lakh 64,200.
No, 47.
And
it's okay.
It came 74 and has also already received
33.
Your Lordship, that is not the amount, Your Lordship.
For my claim is 47 lakh.
No, you see para 10.
Yes.
Claim by him amounts to 70. You claim for 74 lakhs, correct?
Yes, Lordship.
Now they say they've paid you 33 lakhs and the remaining balance only is 25.
Yes,
That
Lordship.
means your total is like
59, Your Lordship.
59.
59 lakhs.
Thomas? No, there's going to come the total value of the formal work orders issued to the petitioner is only of rupees 59 lakhs 10,723. However, she submits the petition may be closed if the petitioner is willing to accept the amounts as fixed by the state respondents or given in the affidavit.
Lordship.
Next paragraph. I've heard the counsels for the parties peruse the affidavit, especially para 10, which is reproduced here and under for the sake of convenience. Stop. Next paragraph. As the petitioner is prepared to accept the terms as laid out, amount as laid out in the set paragraph mentioned, the writ petition only stands closed and disposed of.
Some time frame may be given at least for to pay that remaining balance
It is
amount.
expected that the amount be cleared most expeditiously.
Much obliged, Lordship.
Yes.
Much obliged.
Yes.
Lordship, if they don't give some prime time, they may keep it a long time.
Expeditiously, yes. Preferably with a period of 6 months from today.
Lordship, yes.
Much obliged,
Yeah.
Lordship.
Much obliged, Lordship.
How many articles are asking? How long is it? Who's for the petitioner?
Please, Your Lordship, I apply for the petitioner. Your Lordship, this will take about 10-15 minutes. But I've challenged the order where I was declared medically unfit on the grounds of tremors.
Yes. Yes, Mr. You ready with matter, Dr. Mojika? As we take it after lunch?
Very
2:30, yes.
In that case, tomorrow.
Yes?
In that case, can I have tomorrow?
Tomorrow the school will be here till 12 o'clock.
Or Monday.
DSG is asking for Monday.
Please, Your Lordship, may give it Monday.
Yes.
30.
On the prayer, huh?
That's voice.
Yes, this matter on Monday. Yes.
30.
Mr. Pathak.
Yes, if Your Lordship is about to rise, we can have it on 26th then, my Lord. I'll be also available there.
Yes, 26, this one 26, request Mr. B. Pathak. Yes. You'll be here 26?
Yes, my Lord.